An emotional scene inside the courtroom here in downtown Phoenix as the jury announces that they have not been able to reach a decision. The judge declares a mistrial, and then they move on to sentencing, now scheduled for the 13th of March. And I want to bring in Hector Diaz. We're seeing an emotional scene, first of all, in this courtroom because I think many people wanted to see the death penalty here. Travis Alexander's family certainly made it clear justice for them was the death penalty and the death penalty only, even though it seems fairly clear she's going to spend a life in prison. This judge has the option, certainly, of allowing for release after 25 years, but given the brutality of the crime and the circumstances of the evidence, that seems highly unlikely.
Very unlikely. I think the consensus is that this court, having sat through the testimony more than just this phase and seeing essentially all the evidence that the state presented as to guilt and then the evidence that they presented in aggravation, I'd be absolutely surprised if there was anything but natural life in this case.
There's a couple of housekeeping items that the judge mentioned just to clarify about a pre-sentence interview, a pre-sentence report. Those are standard actions that are taken prior to sentencing. The defense opting not to take part in those, it doesn't really matter at this point, does it?
It doesn't. It really doesn't. Essentially, you have a sentencing date set for April 13th. The court, though, or the defense, can actually push that back if they need additional time. So it wouldn't be surprising to me that the defense could ask for an additional 30 days in order to prepare to make a presentation to the court, because even though the court, we all believe, is going to impose a natural life sentence, she still has the essentially at her discretion to impose the eligibility after 25 years. So even though we may not, the consensus is we don't believe it, they still can present some testimony to the court or some statements to the court.
And a lot of people might look at this and say, what's left that the court hasn't heard at this point in terms of mitigating circumstances? Right. We've gone months here in two different phases of this trial, hearing virtually every kind of mitigating circumstance you can imagine.
For sure, and it's you're going to be walking a fine line if you're in Jodi Arias' camp at this point, because you're right, she's heard it all. So the state now has the opportunity to present further statements, not testimony. They're not subject to cross-examination, but testimony from the Alexander family. I don't know that they would want to do that again, given how absolutely emotional and heart-wrenching it's been for them to be up there.
When you look in the courtroom here, there were actually jurors from the previous trial sitting with the Alexander family, which gives you an indication of just how divisive this has been on this jury and or on the previous jury, and one would assume on this jury as well. In a death penalty case, obviously, every juror answers the question at the beginning, yes, I could vote for the death penalty. But things change when you start to hear all of that testimony.
Absolutely. We spoke yesterday briefly to a juror that was an alternate juror in the first case. And essentially, she said exactly what you laid out. When she came into it with an open mind, indicated that she could vote for the death penalty. But when she sat in the trial and saw the photographs, the incredibly gruesome, the brutality, it was very clear to her that this was absolutely a death penalty case. Now, she was an alternate and was not given the chance to make a decision in this case. But that was something in the first case that was absolutely drilled into the jurors' minds by Juan Martinez over 30-plus days. In this case, they had 5 days.
We saw evidence that Arias planned the crime. We saw Arias that she tried to cover it up. Obviously, the brutality of the case. But the defense really adapted a different strategy here this second time around, really choosing to put Travis Alexander on trial and his behavior in that relationship, looking into Jodi's past as well. From a defense point of view, does that make a difference? Because it would certainly seem to be a very different move, perhaps even a risky move.
You know, the playbook on going after a victim, the way that they went after Travis in this case, that's just not in the script. But here, I think it was calculated in combination with the mental illness component with Jodi. So essentially, it was not an excuse, not providing an excuse for Jodi's actions, but really more so explaining what could have contributed to what she did, the reason that she acted the way she did. And so what you had there was that we heard a lot of Dr. Jekyll and Mr. Hyde testimony from Travis Alexander, that he had multiple girlfriends, that he was somebody who had engaged in mental abuse, physical abuse to Jodi. And so that is, again, it's very risky because as we heard yesterday from an alternate juror in the first case, they were offended. Every time that they went after Travis, it was, in their minds, it was just absolutely inappropriate.
Yeah, because it almost seems like they're attempting to justify the brutality of the crime.
Right.
Hector, thanks so much. And we're going to be continuing to watch. As you know, some of those jurors now do have the option of coming out, talking about what happened in deliberations, talking about what was on their minds in that decision-making process. We're going to be looking to try to speak with some of them here outside the courthouse, as well as prosecutors, defense attorneys as well. All of this still playing out here, down here. We're going to be covering it for you and monitoring it all day long, guys.